Good day, Advocate Holland-Müter.
Good day, Chief Justice and all the other commissioners.
Are you well, sir?
Yes, I am. Nervous but well.
Yeah, no. It's normal to be nervous when on that chair. If it is any comfort, I've seen a few Supreme Court of Appeal judges sitting there applying for a constitutional court position, admitting to being nervous. So it's don't worry about it.
Thank you, Chief Justice.
Yes. You were a prosecutor and then a magistrate and a lecturer at some stage.
Yes, Chief Justice.
For how many years were you a magistrate?
I was appointed in January 1980 as a magistrate up until November 86, before I went to the Justice College from the beginning of 87. I went to the Justice College at 88.
And your responsibilities at Magistrates College were not quite divorced from what a magistrate is supposed to know and do, were they?
Chief Justice, I was in Witbank, and at that stage, the magistrates were also the representatives of other government departments who did not have regional offices. So we did all the other, but for Home Affairs who had an office there, we did all the other, we called it other departments' work, such as income tax, and all that was done in the beginning at the magistrate's office in the rural areas.
But your role at Magistrates College, was it not to train magistrates among other things?
No, not while I was at the magistrate court, but when I was at the Justice College for 10 years, it was for the training of magistrates, prosecutors, yes.
Yes. And you've been an advocate for some 21 years?
Yes.
And for how many weeks or months have you acted in total?
On the spreadsheet, if I'm correct, it's 53 weeks, and it's all over the spectrum, from the criminal courts, civil courts, appeals. It is on the spreadsheet.
Yes. And you haven't applied before, have you?
I applied last year, but I was not shortlisted,
yes.
Chief Justice.
Any reason why you didn't apply much earlier?
No specific reason, Chief Justice. It is just that I started acting middle 2015, and I thought I would first have to gain some experience before I apply.
Yes.
And at the beginning of 2018, I thought it was time to start applying.
Yes. JP?
Thank you very much, Chief Justice. Good morning, Johan. You don't mind I call you Johan?
Well, it's actually John, JP, but you will recall that when the chairperson introduced me to you as Van der Merwe, which was also not correct. I'm John Holland-Müter, but you can call me John.
Well, you've taken the opportunity to correct me at the JSC.
No.
I've always called you Johan.
No, sometimes you called me John as well. It's just an Afrikaans version, Johan and John.
Thanks for that. As the CJ led you, you've done 53 weeks
Yes.
of acting.
JP.
I see that in the opposed motion court in particular, you've done a full 11 weeks.
Yes.
That's a tough court. Am I wrong?
Yes. In the beginning, it was more than later on when you become acquainted to that. But in the beginning, you even read the returns of service because you have to read everything. No, it is tough, but it was manageable.
Yeah. Your background is criminal law, in essence, isn't it? Until you started practicing as an advocate.
No. I was a prosecutor,
Yes.
and then I was a criminal and a civil magistrate.
Yes.
And I was for 8 months before I was transferred to the Justice College. I was in the civil division in the Pretoria Magistrate Court. So it's both criminal and civil magistrates.
Now, in the 11 weeks where you did oppose motions, what was the average time it took to hand down your judgments?
JP, the average time was between 4 and 7 to 8 weeks, because every time, most of the times occurred that the opposed week was the week before I finished, and then I go back to my practice, and so you have to do it in between. There was 2 judgments which were longer, but those were trial judgments. The one was a civil trial, which lasted for 10 days over a prolonged period because there were eventually 11 mechanical and engineering experts called, but in the motion court, 4 to 7 weeks.
Yeah. Could you explain to the Commission what the RAF recess is? I see you've done 3 weeks there.
Sorry, can you repeat?
The RAF recess.
The RAF recess is an initiative when the former chairperson, now Judge Davis, in Pretoria High Court, was approached by the Deputy Judge President with regard to whether we can avail senior practitioners over the recess period so that we can try and work off on a voluntary basis during the recess RAF matters. And I was involved together with now Judge Davis and the convener at the GCB for National, Untitled JSC, to compile a list of available, or to request a list of available seniors and silks who would be avail themselves for this, and this is how it happened.
I see. Well, it's an effort to stem the the road accident fund backlog that's building up all the time.
Yes. If I can explain that, normally in the recess, there were between 5 to 6 practitioners who sat, and each of them were allocated for that week between 10 and 12 RAF matters. So it boils down that in a 4-week recess, the 1st July, approximately 150 cases were worked down.
Yes. Now, I've looked at your list of judgments. If I'm not mistaken, you've handed down a total of some 49 judgments.
Yes.
That's what the list suggests. Of those 49, 11 are in the criminal law arena.
Yes, 2 of those were trials, the rest were criminal appeals, and one was a full bench POCO appeal.
Yeah. You did 3 weeks in the agent court.
Yes.
How did you deal with the judgments in those 3 weeks? Did you
longest,
write them out? Did you write them out, or did you hand down extemporaries?
The majority were handed down extempore. But the longest which I took to give a written judgment out of the urgent court was 2 weeks.
Yes.
The last time was now in early September in Pretoria.
Yeah. When you sat in the opposed motion courts, how many of those judgments that you handed down there were extempore, or are you able to tell us? If any, that is. Or did you write them all out?
No. More or less 50-50 were handed down extempore. The rest were reserved and handed down later.
Yeah. What's the criteria?
The criteria, JP, is depending on the kind of application. Before you get it, you get the files about a week in advance. You go through it, and then you can, to a large extent, out of the papers as well as the heads of arguments, have a prima facie view in which direction it will go.
Thank you, Chief Justice. I've got no further questions.
Many thanks, JP. MEC?
No questions. No questions.
Thank you, MEC. Honorable Nyambi?
Thank you, CJ. Morning.
Good morning, Commissioner.
I've got only one question. Looking at your employment history, the one of 1979 and 1980 is the one that is not clear to me.
It was compulsory military service.
If you can share with us what was happening.
At that stage, there was a system that all white citizens were called up for compulsory military service. In 1977, it became 2 years. Before that, it was 1 year. So you were actually, in terms of legislation, compelled to serve national service in the defense force.
Thank you, CJ.
Thank you so much, Commissioner Nyambi. Commissioner Sigogo?
Thank you, CJ. Good afternoon.
Good afternoon, Commissioner.
The Blacklist Association commented on your application, and they are of the view that you need some more time to act. What is your reaction to that?
Can you just repeat?
The Blacklist Association,
Yes.
in their response to your application, made reference to your stint
Yeah.
of acting as well as your age. What is your comment to that?
With regard to the fact that I did not act for a whole term at once, I can say is that I had to act as my practice allowed, and in arrangements with the JP, to the later stages, it became a half a term. So it was because I'm at the moment still in practice. The question of my age, I do not see my age as to be something to disqualify me. I can, and my health is in such a state that I can serve for at least the next 9 to 10 years. So it in my view, should not be a disqualification. I also know that in the past there were male judges appointed in their mid-60s the past 4 to 5 years.
Thank you. I need to commend you for your pro bono work, where you assisted in court to reduce the backlog. Thank you, Chief Justice.
Thank you,
Thank you
Commissioner.
so much, Commissioner. And Portfolio Committee Chair?
Thank you, CJ. Good afternoon, Advocate Mata.
Good afternoon, Commissioner.
What has struck me in your CV is that you were able to engage your instructing attorneys to brief your junior that you are mentoring that she must be given work instead of you. What was the response from your attorneys?
No,
And the fact that it came from you, do you think it made any difference?
at that stage, I was not yet a silk, and I may just comment that the letters patent was only signed towards September this year. So, but I deemed it necessary to engage with juniors, and that was the one, Leonie Pretorius, which I engaged. But I also had a couple of other juniors later. It was positive response from my attorneys. I did it on a sharing on my fee, so it was not an extra expense for clients. It was to expose these juniors and to practice. And how I identified those juniors is when we do pupil training at the first workshop towards the end of March of each year. It's normally an unopposed divorce workshop, and there we are divided into groups, and you get about 6 to 8 juniors or pupils. And at that stage, I identify out of those groups young females, white and black, who can benefit from being assisted. And then I take them under my wings for the rest of the year. Although I'm not their mentor, I take them with me. On a voluntary basis, they can report back to me when they prepare documents for their mentors, etc., that they can come and discuss it with me. It's just part of passing over skills to these. To answer your question, my attorneys were very satisfied, and 3 of those I've already recommended to my attorneys, normal attorneys, to take over junior work, which I deem not necessary for me to do, but for them to do.
Thank you, CJ.
Thank you, Chair. Mpofu SC.
Thank you very much, CJ. Good morning, Advocate.
Good day, Commissioner.
How are you?
I'm well, thank you.
Okay, thanks. It's Johan van der Merwe.
Well, that is just a nickname which the then Chair Bottas used to try and confuse the JP.
Yes. Yeah, I think the JP had a different person acting than the one who arrived. Okay. Do you? I'm just checking. I'm covered on the question of the transformation, but it seems that you shortchanged yourself by referring only to Miss Leonie Pretorius. Who's Miss Leonie Pretorius, by the way? Is she a colored lady or a white lady?
She is a junior. She did a pupillage on our floor in High Court chambers. But she was also in that first group that year where I was the lecturer who did the practical training, and I identified her there. And I saw potential in her, such as I've seen potential in the last 2 years in two, I think, very, very, very competent black ladies, which I'm doing the same with.
Yes. Okay. In fact, that's what I wanted to find out. Yes, that's what I wanted to follow up on the others, because from the answer that you gave to Commissioner Magwanishe, it became clear to me. That's why I was saying you shortchanged yourself by just mentioning her. Can you give us the names of the others?
It's Nicole Dube. She originates from Mpumalanga, and the latest this year is Nosipo Kumalo. She comes from Tsanin.
Okay.
The reason why I took Nosipo on is because although she is a very competent person, she's very, very drawn back and shy. And I deemed it necessary to take her on and to help her to build her confidence. And in preparing for what we have in Pretoria, in the July recess, we do prepare pupils for the GCB exam. We have mock exams. And I requested Nosipo to come to me so that I can assist her. She worked out previous exam papers, and I can take her and I can give her guidance how to answer it. And although we haven't received the results, it will only be out on Monday, I have no fear that she's going to fail.
Yeah. And just as a follow-up, in respect of all these people, it's the same kind of assistance, junior briefs, fee sharing,
Yes.
introduction to attorneys.
Yeah.
Thank you.
There are also there's Glenda and Swanepoel who I've referred to other attorneys, because I feel our young females are neglected in the briefing pattern, because a lot of attorneys go to, if they see the list, to young males and so on, and we have to do that with them to give them also standing.
Thank you. No, that's a great thing that you've done there. Then finally, just a quick one. Why did it take you so long to apply for silk?
I applied the first time 3 years ago, and the system and you would be well aware of that, Commissioner, also in Johannesburg, is that a silk committee is convened by the Bar Council.
Yes.
And then they decide on that, and they decide on a specific number for that year, depending on the ratio between silks and non-silks and so on. And it just happened, and we also know that no reasons are given if your application does not exceed. And I persisted, and in 2018 they recommended me.
Okay. Thank you. Thank you very much. Thanks, CJ.
Thank you, SC. Honorable Dodovu.
Thank you very much, CJ. Afternoon, Johan.
Good day, Commissioner.
I can see that you are well experienced as a judicial officer or magistrate in this case. And when I look at your profile, you started around 1980, 1989.
I was appointed in 1981.
Yes, I can see that.
I started the first time as a magistrate, an
Yes.
additional, yes.
And at that time, the application of what is called the doctrine of common purpose was very, very much prevalent. Did you preside over any case which had to do with common purpose? And
Yes.
if so, what was your experience?
Yes, I did. Even the last time, it was now in June in the Johannesburg High Court where I presided there in a full criminal trial. Common purpose was at stake. It is a difficult thing because it is much of it is on circumstantial evidence, and you have to look at and out of the actions of each party, you have to come to a conclusion that there was a common purpose. So you have to find something. Yeah, it's difficult, but in my own view, I deem myself competent to do so with my experience.
Yes, just following that up, in terms of Section 25 of the Constitution, specifically that deals with the rights of the accused persons, how do you align it in the context of the current situation where, you know, the rights of the accused have got to be protected and there must be sensitivities that you take
No, for sure.
into account?
If I can go back to criminal appeals, and that because after the new constitution came into being, I did a lot of criminal appeals and sitting as an acting judge in criminal appeals. You have to go through the record to see whether the presiding magistrate explained the necessary rights to an accused. Necessary rights starting from the right to remain silent, right to legal representation, etc., the right of a fair trial, etc. So, and presiding as when I acted in Johannesburg also now, you have to do the same. There's no shortcut because it may amount to a mistrial if an accused's rights is not properly explained to him.
All right, thank you very much. Or can I take over again?
Well, if it's
Thank you, Commissioner. Commissioner Ngozi Thomas.
Thank you, Madam President. Good morning, sir, or good day.
Good afternoon, ma'am.
Okay, I observed that in the 22 years that you've been in practice, you only had 7 reported judgments. Now, my question to you is, what is the exceptional skill that you'll be bringing to the bench if you were to be appointed against that context of 7 reported judgments in a space of 22 years?
Madam Commissioner, it's not in my hands to have a matter reported. There are people who go through and they decide it's reportable or not. What I can bring to the bench is I bring a lot of experience. I bring a lot of knowledge. I bring proficiency. And I bring an open mind. And if I may, and if you may allow me, I grew up in the 60s, 70s. And after that, the regime changed. We have referred to my national service, which was compulsory. But after a specific incident in the early 80s, my whole approach changed with regard to that. Because when I was called up for national service, I was rather young. And it was compulsory. You did not question the law like every good obeying citizen. And then after, I realized, but it was an unfair and an unnecessary war. The reason why I say that, I was the personnel officer on a specific military camp where there was a conflict, and there were 2 soldiers killed. One a South African citizen, one was an insurgent. And I realized that both of them have family. And up until today, I don't know whether the insurgent's family was informed of his death and how that happened. And that made me think a lot about it, is why are we here? Why are we fighting this war? And my whole approach changed to that. And coming back to the whole situation, what I can bring to the bench is an open mind, caring personality about the whole society, not only about a specific group. not a specific race, not a specific gender, not the whole South Africa. That is what I can bring and what I would like to bring and what I've been doing, and I think my record is clear in the transformation which I've been doing.
Well, thank you. You spoke about the war and all of that and transformation, except my question really is about the technical side of things. Is there any specific technical skill, patent law, something exceptional about you in terms of technical skill that you are bringing to the bench if you were to be appointed?
Well, I bring a lot of technical knowledge with regard to criminal procedure. Because up until now, I lecture the pupils year to year for the past 8 and 9 years on certain aspects of criminal procedure. So I bring a wealth of experience in criminal procedure. I bring a lot of wealth with regard to the law of delicts and the law of contract, which I've done a lot. You mentioned trademarks and patents. No, I'm not a specialist on that. That is one of the few fields which I haven't done. I have done a lot of insolvency work, and there's even a reported matter in Holland-Müter, which we turned in the SCA. It's interrogation in terms of section 388 read with 417. It's Rian Adrian Swart versus Dexney and others. It's not reported in the law reports, but it's reported in Holland-Müter. That was one of my subjects when I was at the Justice College, which I taught. There was the law of insolvency and on company law. So I bring a rather wealth in criminal and civil procedure.
Thank you very much.
Did I answer your question?
Well, you have. Thank you. Appreciate it. Thank you, Madam President.
Honorable Singh.
Thank you, Chief Justice. Good afternoon, Advocate.
Good afternoon, Commissioner.
I look from the judgments that you've included, a number of them relate to the Road Accident Fund. And I think we all know the Road Accident Fund is under strain in terms of the number of claims that are made before it. In your experience, and can you give us advice, have you come across any fraudulent claims where there has been collusion between legal practitioners, doctors, police, and anybody else involved in bringing claims before a court? How have you dealt with that?
Not collusive dealings, but you will recall, and when I was elected to the Pretoria Bar Council 10 years ago, it was the first salvo which was fired, which later became known as the Dirty Dozen. It was a council who were charged of contravening the rules of the bar for double briefing and for overreaching. So yes, I have encountered that. I have seen, and which is a concern to me, and I did not have up until now in my acting capacity the opportunity to investigate that, but I think it's worthwhile taking notice that if you look at the Contingency Fee Agreements Act, how it is, and I put it in commas, abused. Because very often, if not in 95% of cases, there is a separation between merits and the quantum issue. And my view is, as soon as merits have been conceded, and there's a separation, there's no need. But I know the act is there, but there's no need for contingency to continue because you're no longer at risk. So a lot of money can be saved by the fund if they investigate this to see that where merits have been conceded, not only in RAF, but in all others, in medical negligence, etc., if the merits issue is conceded, there's no longer a risk. And in terms of the Road Accident Fund legislation, a party may approach the Road Accident Fund for an advance to pay his experts. So the argument holds no water in my view, is that there is a need to continue after merits have been conceded on contingency. And that can, in my view, bring a big saving. Yes, I've seen that, and I took notice of the practice now in Limpopo, where the judge president there made a ruling that very seldom would you, and it happens in Pretoria, and I don't know the other jurisdictions, where they do merits separately, and then they, after separation, continue with quantum, but only one portion of quantum. It's only, for instance, loss of income. The loss of earning capacity, etc., stands over again because there's a further separation. There's no need for that. And that should be addressed. And if the necessary or the real case on the facts, and if I am in that privileged position to have it, I will investigate it.
No, thank you, Advocate. I'll be very interested to get your suggestions outside of this forum on how we can save money for the taxpayer, because the RAF is becoming a huge, huge drain on the taxpayer of this country.
I might just add, that was one of the reasons why we are doing the pro bono initiative in Pretoria, is to fast track so that we can also assist a plaintiff, because if a plaintiff's case is postponed today, he is lucky if he gets onto the court roll a year in advance. So many of these cases can be done quicker, and it may result in a saving of funds.
Just a final question, Chief Justice. Do you believe that the applicants or the plaintiff or the person that's been involved in an accident is the biggest beneficiary of these claims that are meted out? Or does most of the money go to the lawyers and everybody else, the experts and so on and so forth?
I wouldn't say that most of the money, but a large amount goes to the lawyers. I haven't done a study to see how it compares, but I know there was about 6-7 years ago, there were statistics released which says that about 57% of payouts by the Road Accident Fund up until then was for legal fees, and that is wrong. It cannot be.
Thank you, Chief Justice.
Thank you, Honorable Singh. Commissioner Fourie.
Thank you. Good afternoon.
Afternoon, Mr. Fourie.
I didn't intend asking questions, but I was interested in your answer to the issue of contingency fees. I think there's no doubt that contingency fees are, in certain respects, being abused. And that is obviously not good at all. But I think in general, contingency fees and a contingency agreement promotes access to justice, particularly for the indigent. Now, my question is, you've said that once merits have been settled, there's no risk, and I understood you to say that in such an instance there cannot be a contingency fee regime applicable to quantum. I know that argument, and I know certain people hold that view, but my question is, what then about the indigent? Merits have now been apportioned or settled or conceded or whatever the case may be, but the important phase of quantum, which will hopefully result in money in the pocket of the injured, how will the indigent pursue that if not assisted by way of contingency fees?
No, I, with respect to a certain extent, have to disagree with you, because they already have access to court, because they're already in court on the merits aspect. So the question of access to court, to justice, they're already there. The aspects with regard to the medical expenses to be incurred to get on board your medical experts, there is provision in the Act. So that people that attorneys, practicing attorneys, can incur that expense. The merits have been finalized, and they now can claim that directly. I think it's Section 17 sub 4 of the Road Accident Fund Act. There is a provision that they can go for an advance payment with regard to that, but that seldom happens. I know that because when at some stage about 10 years, 11 years ago, I did for an attorney's firm a lot of these so-called medical claims, where they directly, long before the merits or the quantum issue has been finalized, the medical practitioner submits his invoice, and it was submitted to the road accident fund, and about 90% of those were paid within 60 days. And let me make it clear. There's a balancing act which has to take place because there are instances where the contingency agreement is being abused. I personally know of a matter where, via an attorney, which gave me a lot of work, he's at this stage unfortunately deceased, but another attorney of the rural areas approached him. They had a client. It was a father, 2 sons, and a mother who was involved in the accident. And the one son's claim, which was finalized and the award made by the court was 4.8 million, of which only 2.1 was paid out to him. And after investigating, and we then brought an application against that attorney for rendering his account because he took his 25% plus the tax fees, and not all. And the moment, and yes, they may accuse us of playing dirty. We cited as nominal defendants the fund, and we cited the road accident fund as a nominal respondent. The moment that matter was served on the attorney, he paid 740,000 within a week. He paid that back. So yeah, there is an abuse. There is an abuse, and it needs to be investigated.
Now, I agreed with you, Mr. Holland-Müter, and that should be rooted out.
Yes.
My only question was, you say when merits are conceded, the litigant already has access to the court.
Yeah.
I'm saying when merits are settled or conceded, there's a further process.
No, that
also needs to have access to the court, which is assisted by contingency fee agreements.
Well, yes and no, but there's also the mechanism in Section 17 sub 4, where that can be overcome.
I don't think that's going to solve the problem, but be that as it may.
Thank you.
Thank you so much, sir. You're excused. You are excused.
May I be excused?
Yes, sir.
Thank you. May I just thank all the commissioners for the time you're putting in here. Most of you are also doing it pro bono, I suppose.